For our third case this morning and to be submitted, Ms. Reinkoester, are you ready to begin on Smith?
Thank you. May it please the court. I didn't realize it or plan it when this term started that I was going to have a running theme in my cases, and that is that I was going to come over here and ask you to apply longstanding law. And that's all I'm going to do today, too. Because the idea of post-conviction relief or habeas, the 2255s, were created by Congress in 1948. And ever since 1948, the United States Supreme Court has recognized that a different standard of review applies to a collateral attack on a conviction than is different from the direct appeal on that same conviction. And that's because other interests are at stake once a conviction becomes final. Society has an interest in the finality of the convictions. And so when they are collaterally attacked, we require that they show some prejudice to that error that was made at trial. And here we are talking about a trial error. We're not talking about a guilty plea error or a sentencing error or an appeal error. We're talking about a trial error. And Strickland is very clear that when a defendant attacks a verdict, they must prove that there was a reasonable probability that the fact finder would have come to a different result. That is the only standard to be applied in a case where somebody is challenging their conviction in an error at trial. If we were to accept Smith's theory of prejudice, we would be allowing an end run around Strickland, because it would no longer be but for counsel's professional errors. The result of the proceeding would have been different. It would be that he would be entitled to a more favorable prejudice standard on appeal. And that is not what the law requires. And in his resistance to further review, the defendant, or Mr. Smith here, the applicant, cites the case Davis from the 11th Circuit. And I could stand up here all day and tell you the problems I have with Davis. But fortunately for all of us, I don't have to, because the Florida Supreme Court has already done it for me in their case Caratelli v. State. And I can give you the citation if you want, but it is cited in Dixon, and so the case can be found there.
Give the citation, please.
It is, oh gosh. It is 961 South 2nd, 312. And it's a decision from the Florida Supreme Court in 2007.
What is the incentive for a district court judge to grant strikes for cause as long as they do so within a number of the peremptory strikes? So, in other words, as long as you have enough peremptory strikes to take off the people that you seek to remove for cause, what incentive is there for district courts to get that question right, to get the for cause question right?
Too. They're not an advocate. They're not playing games with the jury. They're not, hoping that it's going to be a certain outcome. They are simply looking juror by juror and deciding under Rule 2.18 whether or not that person should be struck for cause or whether or not they have, enough ability, even if one of the parties may find them objectionable, to be a fair and impartial and an unbiased juror in that particular case.
Pose that duty upon them? How do we enforce good behavior, correct calls on them in this instance?
I think that you need to. I don't see that we have a real issue with district courts getting this wrong over and over and over again. And so, so they have that duty to give a fair and impartial jury to the parties to then make their peremptory strikes. And, I don't. Sure, go ahead.
Getting hearsay questions right, but we can still overrule them, right? We still review those. How do we do it with for-cause strikes?
Okay, so in this particular case, I do think it's hard on appellate review to make a determination about for-cause strikes, about whether or not the district court got it right when they were making that determination. And I'm not going to stand up here and tell you that Juror K was an easy decision. I'm not. That's a difficult decision to make. But that's why I think, and the law seems to recognize, that in those difficult cases, we need to defer to the district court's decision, because they had something that none of us did. They could see the person give the answer in real time, could read their body language, could hear their inflections, could understand what was happening, and make that decision.
Justice McDermott's question, or maybe something else that he's making me think of in a different way. I mean, your position amounts to ineffective assistance by defense lawyer with regard to Jonas is not, you can't collaterally attack it. You can't do a PCR on it.
And we know that from the Dixon case.
If the lawyer's ineffective and doesn't follow Jonas at trial, when can you ever get PCR?
Biased juror sits on the jury, and that is precisely what happened in the Dixon case. When that case went to the Court of Appeals, there was a juror or a veneer member who stated, "I think the defendant is guilty, full stop, could not be moved off that position."
That's any error. I mean, that's not a Jonas. That's you.
In the sense that the lawyer then did not strike that person from the jury, and that person sat. So they made an error in voir dire. And so the prejudice that has to be established then is that an actually biased juror sat on the jury. And that is exactly what happened in Dixon, and that's exactly why the conviction got overturned. And that's what would happen in a Jonas case. If someone did not ask or follow, for the extra peremptories and did not follow the Jonas protocol, I mean, first of all, they can just do this on direct appeal anyway. They can still do this under Neuendorf. There's nothing preventing them from doing that. And second of all, if they could then prove and show that we're not just talking about, I wanted a slightly different person, we're not just swapping one impartial juror for another impartial juror, that then you can look at the record and determine if an actually biased juror sat on the jury, then they would have been entitled to collateral relief.
The Court of Appeals analysis kind of superficially makes sense, but the real problem as I see it is this is not a Jonas issue, because Jonas says the defense counsel has to request additional peremptories and the district court has to deny them. And we don't know what the district court would have done if that request would have been made. So we're not in a Jonas problem situation. We're looking at kind of an actual bias situation, it seems to me, which I think is what you're saying is, since we don't know what the district court would have done if peremptories were asked, we can only look at actual bias.
Correct, and I think on that point too, there's a real failure of proof here in Smith's application, which is that they never even approached that topic. They never introduced any evidence about what the district court might have done under those circumstances.
So if the district court denied the for-cause strike, do we really think the district court is going to say, well, I might have been wrong about that, so I'm going to give you another peremptory? I mean, isn't that just sort of a game a little bit, right? I mean, was Jonas just wrong?
I'm never going to say that Jonas was right. I think Jonas is very wrong. But I will say that under the Jonas scheme, I have seen district courts reevaluate their rulings when somebody employs the asking for peremptory jurors. For peremptory strikes. So I have seen district courts, I've had some where when they raise it again, they go back over the record just to make sure of their decision. Or they actually do grant it to just give the remedy there, even if they maybe don't agree that they did anything wrong, that they excused the people that they should have excused and didn't, to just go ahead and give a remedy right there so there wouldn't be a remedy on appeal.
Prosecutor could have done that too. Prosecutor said, all right, I agree this juror can be stricken.
I agree, but the prosecutor, in this case, the prosecutor didn't take a side on these particular jurors. I don't think in the record she really took a side on any of them. It was up to the defense lawyer to make the strikes that he wanted to make. And I can say that I went back through the record, and nobody where a defendant raised a motion to strike served on the jury. So every single person who was left in the jury none of them had a motion to strike made against them by defense counsel or the state.
He can educate us on this topic, but I would think the practice as a district court judge, if I had read Jonas, is if I denied a motion for cause, I would just grant the defendant as many additional peremptories as the defendant wanted, and you're just bulletproofing the trial record. I mean, I would be stunned if district court judges were denying motions to strike jurors for cause and then also denying additional requests for peremptories following Jonas. And maybe that is occurring. I haven't seen it. I would be really surprised if any district court judge would approach it that way when trying to make a decent record for appeal.
So I will say it has happened. And that was a time where the court went back and spent a significant amount of time going over the record again to make sure about their decision on the motion to strike. So it does happen, and I think maybe sometimes it might happen if how much of the jury pool is left. Like if you could give someone just unlimited peremptories, maybe you would, but it might depend on how many veneer people you have left to even use for that. But going back to the prejudice part of this isn't simply, even if the district court erred here, and even if his trial counsel should have asked for more peremptory strikes, that does not mean he gets a reversal because he may have been entitled to reversal on direct appeal. He still has to prove the Strickland prejudice here, which, as the cases have shown from Dixon, which is of course an unpublished from the Court of Appeals, but Florida and a few other states, they apply an actually biased juror must have sat on the jury because that undermines our confidence that the verdict was reached on the evidence alone. And that is the correct standard. That's the correct standard from Strickland. And I don't think even Flores Ortega can be read as broadly as the Dixon court read it. That was a case where someone was wholly denied an appeal, wholly denied. Didn't get a particular issue on appeal, not a particular type of review on appeal, but wholly denied. And the Supreme Court, the United States Supreme Court, has been very consistent that when a defendant is wholly denied a proceeding that they are otherwise entitled to, that the prejudice standard is a lot lower. It's not, you don't have to prove that you would have had a meritorious claim. You only have to show that you would have wanted that proceeding. So you would have wanted to go to trial. You would have wanted to appeal your case. That's what the prejudice standard is in those cases.
Is kind of the thrust of Weaver versus Massachusetts relevant here and what the court said about how you apply Strickland in these maybe unknown situations?
It's very instructive here, especially because I think Weaver looms large over a lot of these cases, even if it doesn't specifically address them, because in Weaver, we had a structural error. The defendant's trial was closed to the public. And if his lawyer had raised that, he would have gotten a new trial, no doubt, on direct appeal. Everyone agrees with that. But when it was raised in PCR, the United States Supreme Court recognized what they've always recognized, which is that those proceedings are entitled to different review because there are different policy concerns involved. And there, they still had to prove Strickland prejudice in order to achieve a new trial.
Weaver and Sothman.
And I think this court's precedents are very consistent and very consistently apply Strickland correctly. From, I just want to say Ledesma, but it's like Ledesma to Maxwell to Lorenzo Balthazar to Sothman. That's what I'm saying is nothing new. This court has said it over and over and over again. So, I mean, that's what the standard is. And why I think Weaver is even more instructive is that we're talking in Weaver of a structural error, like a pure constitutional wrong, that the defendant, he did not get something he was constitutionally entitled to. In a case like this, we're not talking about constitutional error. The Constitution is not involved. This is a rule-based error.
The Court of Appeals decision stand, what are the consequences going forward?
Use Maxwell, Lorenzo Balthazar, Sothman, maybe not Sothman because that's a Weaver case. So that might go its own path. But I think you will lose all of those cases because what we would then be doing is anytime someone failed to preserve an error, you would just be applying the same review in PCR that you would on direct appeal. And I think, the Florida Supreme Court and Caratelli said it best. They said, if we're going to do that, why wouldn't we just review errors on direct appeal that aren't preserved? But then that means that someone can wait until appeal to raise any issue, and they said, we're not willing to go down that dangerous path. Thank you. I'll wait till rebuttal for the rest. Thank you.
Justice Waterman, and may it please the court, my name is Gary Dickey of Dickey, Campbell, and Sahag Law Firm in Des Moines, Iowa, appearing on behalf of Timothy Smith, who asked this court to affirm the Court of Appeals' decision to grant him post-conviction relief and to remand for a new trial. The Court of Appeals, the majority opinion of the Court of Appeals applied Strickland faithfully, and I depart from my friend's analysis from the state in that if you look, they seem to be staking out the position that in order for Mr. Smith to prevail, he has to show some type of actual innocence, and that's just not true. Strickland itself tells us that, because Strickland was a sentencing error where his trial counsel failed to present mitigating evidence that resulted in a capital sentence. It didn't even involve a trial error. What Strickland tells us by its plain language is that prejudice is established if the error is sufficient to undermine the confidence in the outcome of the procedure. So that's the proceeding. So that there's 2 points to that that are important. One is we don't have to show actual prejudice. We have to show something that is sufficient to undermine the confidence. And the second part that's important is you analyze the proceeding, not the defendant's guilt or innocence. For example, in Iniga, which we cited in our resistance to further review, that was the failure to file a motion to dismiss based on speedy indictment after he had pled guilty. So guilt or innocence wasn't an issue. He was factually and legally guilty. He admitted it, but his trial counsel's failure to provide to file a motion to dismiss undermined the confidence.
Concern, which is, in one sense, the Court of Appeals, when you first read it, you'd say, okay, that seems kind of right. And then I'll tell you I know you believe it's right, and maybe you're correct, but address this concern for me then. It seems like you're getting more relief here than Jonas actually provides. So what Jonas says is to get relief, you have to show the district court improperly denied a for-cause challenge, that the defendant used a peremptory to strike the juror, or I suppose in this case, maybe the state struck 2 of them and the defendant struck 2, if I think that's correct. The defendant requests an additional peremptory restrike, which is what you claim counsel was ineffective for not doing. But then you also have to show on direct appeal the district court denied the request for additional peremptories. And so there's no way to show that here. There's no record about this here. So your client's actually getting more relief. He's showing less than what Jonas requires because we don't know what the district court would have done.
So I have 3 responses to that. So I think we can surmise from the district court's decision in post-conviction relief what the trial court would have done. The district court in post-conviction relief, and it's on page 5 of the opinion, says, well, because these jurors were all stricken, there's no error at all. And if that's the belief on post-conviction relief, there's no reason to believe that the actual district court judge would have thought any different. And so if the district court judge, so the idea is there's no harm, no foul because no bias.
District court judges, and again, you're down there more than I am at this point, but I would think if I were a district court judge and you had a close call on a for-cause challenge, like some of these were, and the defendant said, I would like some additional peremptories because I think you should have granted the for-cause challenge. If I had a sufficient number of jurors, I would just say, okay, that's fine. Let's move on, make your record. Isn't that the practice? I don't see this issue of judges being really stingy with granting additional peremptories in this circumstance.
The record, I'll tell you, in my professional experience, I've never seen a single judge do that. Now, the reality is post-Jonas, my experience is that judges have been less stingy on granting challenges for causes. So we see that as so practically, I don't think we see Jonas coming into effect quite a bit because most of the time, if somebody says, I'm having a difficulty giving somebody the presumption of innocence, then they're stricken.
The trial judge can't rehabilitate the juror on their own? Has that had an impact?
Yes. So Jonas tells us do not rehabilitate. The bench book tells us do not rehabilitate. The Court of Appeals Jonas decision says do not rehabilitate. All of the other, we cite several other jurisdictions on page 26 through 29 say do not rehabilitate. All of the best practices say do not rehabilitate. And there was, so I understand Justice Waterman's concurring opinion in Jonas, and there may be instances in which the proper form of rehabilitation may not be prejudicial. That's not what we have here. When you have a district court judge that looks a juror in the eye and says, can you be fair and impartial and render a true verdict, or can you follow the instructions? I mean, essentially the district court is saying, can you be fair and impartial, or are you just a bad person? And nobody reasonably is going to say, yes, I'm a bad person, I can't follow, I can't be fair. And when you say, can you follow instructions, what the trial judge is really saying is, can you follow instructions, or do you lack the mental capacity, to follow a recipe when I give you a jury instruction? And so it was the particular way in which the rehabilitation took place. That is why, my friend says that this is a rule-based problem. It's not. Behind 2.18 is the Sixth Amendment in Article 1, Section 10 of the Iowa Constitution, which guarantees a right to an impartial jury. Now, constitutionally, under the Sixth Amendment, and this is the Adams case that we cite in our brief, the standard is, are you substantially impaired in your abilities to carry out your duties as a juror? Unfortunately, that is not what the standard in 2.18 is. I don't think the rule is caught up with the constitutional standard. But using the Sixth Amendment, had the judge said, sir, or I guess Juror K was a female, Ms. K, do you think you would be substantially impaired in your ability to hear the evidence in this case based on your view that the defendant is guilty until he takes the stand and proves himself innocent? Perhaps that type of rehabilitation would have been okay, but that's not what we have on this record. So there is no per se rule against rehabilitation, and I'm open to a proper form of rehabilitation that just wasn't present in this case. But Justice McDonald, to address your question, one other thing we can look at is the Court of Appeals opinion from 2020, in which they kicked the can down the road, but essentially reading between the lines, the Court of Appeals said, you have a real Jonas problem here. And they actually threw the trial attorney a bone by allowing him the opportunity in post-conviction relief to provide some type of strategic reason why he would not have followed the Jonas protocol. But reading between the lines in the Court of Appeals decision, they were ready to grant relief under Jonas.
Jonas announces the rule, but what was the actual disposition of the direct appeal in Jonas?
It was determined that he should have been stricken, but because his views on homosexuality, but the district court was affirmed because he didn't show actual bias, because he did not follow the Jonas four-step protocol.
In the follow-up then, so the district court was affirmed because he didn't follow the Jonas protocol, which was announced in that case. Jonas filed for post-conviction relief, and unless I'm wrong, he actually lost his case on post-conviction relief because there was no showing of prejudice, which is what the state says has to be shown here. Wouldn't it be odd that if Jonas himself didn't get the relief now that you're requesting?
So I think what you can, I don't know, I'm not sure that that's a subsequent reported opinion. If it is, I don't know that that was cited in the briefs. What I can tell you is the trial counsel in Jonas, I think Jonas announces a new law. And so you get into this whole Strickland prong one where we don't expect Jonas's trial counsel to be a crystal gazer and to anticipate changes in the law. And reasonably relying upon moots, he could have assumed that, he was reasonable to assume presumed prejudice or actual prejudice, and therefore didn't need to make the objection.
In all fairness, I mean, if you haven't read the case, you haven't read the case, but this is what the Court of Appeal says. In Jonas's case on post-conviction relief, we conclude there's no reasonable probability of a different result had Jonas's attorney asked for an additional peremptory strike for one of the two identified jurors. I mean, they resolved it on Strickland prejudice grounds.
And I guess I don't, As the case law existed pre-Jonas, I don't know, that's probably correct analysis. But after Jonas, it is clear, I call it the Jonas three-step. You make your objection, or you ask to strike for cause, it's denied. You ask for additional peremptories, and then you have to identify the other jurors. So I call it a Jonas three-step. Mr. Smith's trial counsel didn't even read the Jonas case. And so he wasn't even prepared to preserve the right. And so when you're looking at Strickland 1, was there ineffective assistance of counsel, looking at the ABA standards, ABA standard 4-7.3 says that trial counsel has to know the standards for making peremptory challenges. He clearly breached that essential duty. Standard 4-1.5 says that you, at all stages in a case, have to preserve error for appeal. And he clearly did not do that.
I'm gonna circle back to kind of where you started. So you were comparing this case to Enninga, which that was the case you won, as I remember. So you know it better than I do. But I mean, the conclusion was the lawyer was ineffective because if they had filed the motion, the indictment, information would have been dismissed, and the defendant wouldn't have had to plead guilty. So, in a sense, the overall proceeding would have had a different outcome. In this case, it sounds to me like you're trying to parse the proceeding into like the voir dire, because the overall proceeding is the trial, right? And what Ms. Reinkoester is saying is that there has to be a reasonable probability that that proceeding would have come out differently, right?
Proceedings that are at issue, first is the voir dire, and the second is the appeal. And we have to win on both of those. I will concede that. And so there is such a thing as ineffective assistance of appellate counsel. That's been recognized. The cases we cite in our resistance to further review, you've got the Davis case, which federal case applying Strickland federally found that losing the deferential standard on direct review by failure to preserve the Batson challenge was Strickland prejudice. You have the Burns case from 2001 from the Eighth Circuit, where the failure to object and preserve an issue and therefore losing the more deferential standard on direct appeal is Strickland prejudice. And so there's all kinds of cases in which there's Strickland prong 1 and 2 where you don't evaluate the person's ultimate guilt or innocence. Enninga, Strickland itself, all kinds of capital cases in which there's ineffective assistance in the sentencing phase, which has nothing to do with guilt or innocence. So if this is not a situation in which it's a hearsay objection in which it prejudice their deliberations, it's more akin to a structural error, not initially a rule-based.
But then when you mention structural error, why does Weaver not play a part?
I don't think you need to get to Weaver because Jonas says it's actual prejudice. I mean, the Court of Appeals.
Walk me through this. If the Court of Appeals is right, then the lawyer does not ask for the extra peremptories, so it doesn't give the district court the opportunity to give them, and then it comes up on PCR, and then they automatically get a new trial, which seems to be, to the state's point, I think they made, you get more rights than if you wait and if you're ineffective and you do it on PCR. So why wouldn't an attorney just always not ask, wait for PCR, and then I'm going to get a new trial? Isn't that kind of the sandbagging that we were talking about in Jonas? Or what am I missing?
So if the worry is defense counsel intentionally sandbagging, that would be a legitimate worry. I just, if we're asking about real life experience, I don't want to have to send a note to my malpractice carrier to try to sandbag a Jonas issue for a client that I'm getting paid $70 an hour.
Wouldn't be malpractice anymore is, I think, Justice Oxley's point, right?
Send a notice to the professional grievance committee that I've failed a professional responsibility. I think a defense attorney who intentionally sandbags should be sanctioned, and I should not be representing a client.
If you don't ask the district court and give the district court the opportunity to give you the extra strikes, you might get the extra strikes. Well, now I don't get now I can't sit with that in my pocket. But then after trial and I lose, now I can bring it up on, I'm not going to bring it up on direct appeal, I'll bring it up on PCR and I automatically get a new trial.
I mean, Mr. Smith's been sitting in prison for 4 years. I don't think that this was part of a grand strategy to sandbag to put him in a better position. Trial counsel had legitimate concerns about these 4 witnesses. There are other witnesses or jurors.
Bagging, doesn't it give him a better rights in PCR than he would have had, though?
I guess I'm open to that possibility after 4 years in prison. I'm not sure the trade-off is worth it. I see my time has expired. We ask that this court affirm the Court of Appeals decision. Thank you.
Thank you. So I agree with Mr. Dickey. The defendant was entitled to an impartial jury, and he got one. And he has never, not even today, claimed that he didn't get an impartial jury. It's not in any of his briefing, it was not in his PCR application, and that did not come up at trial. That is what he got. We're simply talking about requests under Jonas for a different appellate procedure. And we're also not requiring the defendant to prove actual innocence. We're talking about legal guilt, not actual innocence. And that is the Strickland standard. And in Nega, that is what it came to. It's about legal guilt. That defendant would legally have never been found guilty or pled guilty because the information was late and should have been dismissed. So it's the same standard. And I want to talk just a little bit about Davis from the 11th Circuit and how they reached the opinion that they did, which is that they drew a strange line, and I think even they recognize it now, between raising and preserving. It was a situation where the lawyer raised motions for cause against jurors, and the district court denied them. And then under Florida law, you are required to renew that objection, very similar to Jonas, before you certify the jury, to give yourself both a chance to look at the jurors you got and make a decision if you're happy or not as the lawyer, and also to give the district court another opportunity to see who's left on the jury and reevaluate their opinion. And Davis read that second part as pro forma, and that the only thing that happened then is that error preservation didn't happen. And of course, the Florida Supreme Court came back in Caratelli and said, that's not pro forma. That is a requirement because that is an error that can be fixed at trial. And that is why we require it, not just to preserve error, but because it is something that can be raised to the trial court. It gives everyone an opportunity to reevaluate the decisions because voir dire is such a dynamic process and make that determination. And so they said, Davis, under that very limited circumstance, we would look to the results of the appeal. But it didn't take them very many years in Purvis to just walk that back. I mean, they haven't completely disavowed it, but they said it is an exceedingly narrow decision. They also said they were pushing things with their interpretation of a Flores-Ortega. And I looked at all of their cases, at least on the circuit level, and they've never applied the standard again in terms of granting someone relief. And it hasn't been widely adopted by any courts. Many circuits have wholly rejected it as incorrect. So this is not a majority opinion. It's a one-off opinion from the 11th Circuit that they have greatly walked back and almost never used again.
What of the argument that Mr. Dickey makes that we can look to the district court in this PCR action to find that the district court in Mr. Smith's case would have denied him an opportunity for more peremptory strikes?
So the district court who ruled on his PCR is not the same judge who was his trial judge. So I don't know that this district court's, this district court, I don't know if how they would have decided things necessarily would have informed, but I will also say this issue was never raised by defendant. So the district court below never even had an opportunity to talk about it. It answered the straightforward questions it was given. Did the district court abuse its discretion when it failed to strike? And did that cause prejudice when the trial counsel didn't ask for additional peremptories under Jonas? So that issue was just never even raised by defendant in this particular case. So we have no indication in the record of how the trial court would have ruled in this particular case.
Affirm the Court of Appeals, do we need to worry about sandbagging?
I mean, it's our position that Jonas, it did try to create, eliminate one type of sandbagging, but it has just kind of created another type of gamesmanship, which is, are you going to follow this procedure, and what's going to happen if you don't? And then we see that here again, where, if that could get your client a better outcome, I don't even know if it's sandbagging. That might be a great decision on a defense lawyer's part, right, to wait. But that's what we don't want to incentivize. We want to incentivize getting errors corrected at trial, and then what errors that were preserved come to the appellate courts for review to ensure that those were the correct decisions. I mean, that is what we want to incentivize here. And I think if we fall...
Fair to require a showing that a biased juror actually served?
Is. Because the right that he's entitled to is an unbiased, impartial jury. That's the right we're trying to vindicate. And if you don't meet that threshold, there's no reason to give you a second trial when your first trial has an impartial jury. You're just doing an entire trial over again with another impartial jury.
Earlier, I think you said you were not going to try to defend the rehabilitation of Juror K. Okay, well, so I'm glad I asked the question then. So are you conceding that at least with one of these 4 jurors should have been struck for cause? Okay.
In other words, I'm not going to say that that wasn't a difficult decision. I'm not saying that looking at the record, that's an easy call to make. What I was saying is that I think in those cases, we should defer to the trial court's, superior vantage point. But in terms of the rehabilitation,
Yeah, I shouldn't have said that. But you're not conceding that the ruling on the four cause challenge was wrong with respect to any of these 4 jurors. Okay.
talking about 2 because the state struck 2. So that analysis doesn't even play in. And I think juror A, for me, that's not as close call. It's certainly not as close as juror K. But yeah, that's simply just, I think in those close cases, I think we need to defer to the trial court's superior vantage point. And I do want to just quickly add that I don't think any rehabilitative efforts really happened here. First of all, they're not forbidden. Even if you read Jonas, it says it is permitted. But the trial court said 2 things to this person. It wasn't a persistent, will you put this aside? And, it wasn't a badgering. It was 2 questions. If a trial court can't ask 2 questions to clarify a juror's state of mind, then it would make their rulings on, these cause challenges even more difficult. Thank you.
State is now submitted, and the court will adjourn for the morning.